Bismillahirrahmanirrahim. Assalamu alaikum. Welcome you to the 19th lecture on the course Management, Organizational Policies and Practices. Before we start with the lecture, I give you a short recap of lecture 18, wherein we discussed equal employment opportunity, the different diversity management issues, and the cases of sexual harassment, how the organization needs to develop its procedures to cater with the problems relating to sexual harassment. So we started off with the equal employment opportunity. We discussed that what we mean by equal employment opportunity, what are the different laws in Pakistan which are dealing with equal employment opportunity. Then we came to the case of sexual harassment. We discussed what is sexual harassment, what are the different ways by which the employees they can prove sexual harassment. We discussed the three different categories of sexual harassment. And we started off with the quid pro quo, and then we saw the hostile environment which is created by the supervisors. We saw how the hostile environment can be created by your co-workers and sometimes also by the non-employees of the organization, such as the customers of the organization, and how the employer that can be held responsible for any such hostile advancement by the co-workers or by the managers and by the non-customers. When are they responsible, when they are not responsible. We also discussed what are the different defenses that the employer can take against the discrimination allegations, right? When those defenses are when those defenses they are actual defenses or they are workable, and when they are not workable, such as when the employer says that he had good intentions but that is not enough, that is not a good defense, and employer may not be able to win the case basing on good intentions. Similarly, employer cannot hide behind the bargaining agreements, or he cannot say that it was the clause, that it was one of the conditions in the collective bargaining that they had with the union representatives that they need to do some discriminatory practices, right? And that cannot be the case. So there are a number of cases wherein the defenses they are the employer can hide behind those defenses, and there are a number of cases wherein the employer cannot hide behind the defenses, right? We also discussed the case of adverse impact, which occurs from the disparate treatment which is caused coming from the employer, and we saw that how this disparate impact it affects a particular protected group in the labor pool, and what are its consequences for that particular labor pool, or and how that particular class or that protected class which is being discriminated against, how by the use of the organizational employment policies or by the use of the unfair labor practices by the organization, how those policies they are discriminatory and how it is affecting them, and how it can prove them. So we considered a number of possibilities which this protected class who's been affected, it can prove the cases in the court, right? And we saw that it can be through the disparate rejection rates, right? And it can be calculated by calculating the percentages between the two groups, between the protected class and the other class which has been hired, that what is the percentage of the rejection rates in the two classes. And then you can see that if the protected class is rejected at a higher rate than the other classes, then there can be some proof of discriminatory practices being used. We also saw the 4/5 rule, wherein the 4/5 of the people who are being hired from the majority, 4/5 of them should, at least 4/5 of them should constitute the minority hirings as well. But if the minority hirings are less than 4/5, 4/5, that it means that that practice is discriminatory. So we discussed these 3-4 options, that how the adverse impact it can be proven, and once the adverse impact is proven by the victim or by the employee, then the burden of proof falls on the employer, right? And employer then has several options to defend his case, right? And I told you that there are several defenses which cannot be made by the employer, or which won't be recognized by the court. right? And the employer may not be able to win his case based on those defenses, such as the good intentions or some discriminatory practices and hiding behind the collective bargaining items or the negotiations, right? So they cannot protect the employer, right? And employer can be protected even when he's using the discriminatory practices. Those practices are not termed as discriminatory. When the employer is using such practices which are which can fall under this bona fide occupational qualifications or which are the business necessity, right? So we had a discussion that how the business necessity, how it can make certain practices non-discriminatory. So if you are able to prove that a certain practice you're adopting because it is a requirement of your business, then that practice does not remain discriminatory. And we also discussed that how the bona fide occupational qualifications, they can make certain practices not discriminatory and the employer can use them as his defense. Then we had a discussion on the discriminatory employment practices, such as which are what are the different forms of those employment practices, or what are those employment practices which form them discriminatory in different stages or at different levels in the organization, such as at the recruitment level and at the selection standards, how your certain practices, they can be discriminatory, such as in the recruitment, the procedure that you use for recruitment or for hirings, that can sometimes be discriminatory. For example, if you're using word of mouth, I told you, if there is a particular majority group in your employees or in your organization, then that majority, if you ask them to refer to you certain a number of workers or some workers, you want to make a new hiring, and you ask the majority group in your organization to refer a person to you, that majority group is most likely going to refer to some person who belongs to that majority group as well, right? So that majority group is much less likely to refer you a person who is belonging to a minority group, right? So therefore this word of mouth, it is going to be a discriminatory practice, because then it is to the disadvantage of the minority group in this case, right? And similarly, if the people of a particular gender are in higher proportion in the organization, for example, there are a lot more males, such as there are around 90% of the males, and you're asking them to refer you to a new hiring, then those males, they are most likely going to refer to a male candidate as well, right? They are and then it is to the disadvantage of the female candidates, right? So this is how it makes them discriminatory, the recruitment practices, by using the word of mouth, for example, right? And then we given a number of we discussed a number of other recruitment practices which make them discriminatory, such as the help wanted ads, how they are discriminatory when we are saying that you need a male or female for this job, unless and until you also prove that that is a business necessity, that practice is discriminatory. Then your selection standards, they're also we discussed a number of selection standards, such as the physical appearance, height, the weight, they should be like that. And sometimes we also see the ads in the newspapers which are stating that the female receptionist wanted with ones with the pleasing personality, right? These are basically discriminatory practices, right? And such practices should not be used, such advertisements should not be used, and such selection standards, they should not be there, right? And then at the time of the trainings, the organizations sometimes use these discriminatory practices. For example, when they have made the hirings, when there is a specific number of females, even when that is in very small proportion compared to the males in the organization, as I told you earlier, that they're not given those opportunities in the international assignments, in their career development, etc., and then those practices are also discriminatory. Similarly, this category of workers, they're also not given equal opportunities to the trainings, to the international trainings, to the multinational trainings, or to that kind of skills, because they are considered less capable to work in those challenging and those tough tasks, and therefore those training opportunities are also not given to the females, but they are more given to the males. And then such practices are also Discriminatory. So practices can be discriminatory at all levels in the organization, starting right from the recruitment to the selection procedures, the selection standards that you use, to the trainings that you provide. Even in the performance evaluations, you can use that discriminatory practices, right? And especially when there are these subjective performance evaluations, the chances of these discriminatory practices are much higher, wherein you are basically biased against women, and you are not giving the performance evaluations of women as positively, even though she might be working very well, equally well, or even in some cases she might be working better than her male counterparts, but still due to this bias in the manager's mind and in the minds of the general people in our society, they are discriminated against, and they are not evaluated. They may not be evaluated that positively on their performance as well, right? So the organization then also needs to see what are the turnover rates of the males and the females in their organization. So that can also be an indicator for if the female rates are the turnover rates, they are higher compared to the male turnover rates, or male turnover rates are higher compared to the female turnover rates. So at the different levels, you need to see that how your employment practices are like, and what makes them discriminatory, and how you can eliminate that element of discrimination in your employment practices. Then we had a discussion on the concept of this diversity management, that why diversity management is important, how the labor force is becoming more and more diverse with every passing day, and what challenges it has for the organizations. We had a discussion on how there can be the different options to deal with these workers, and the managers, they need to be trained to deal with the diversity related issues, and not only the managers and the supervisors, but also the employees and the co-workers, they need to be trained on the diversity management, and they should be given these diversity trainings, that how they have to behave with others, what are the good ways to behave in our work, for example, what are the group norms, and how to behave what are the best ways to exhibit teamwork. We also discussed that what are the different challenges that are posed by this diversity in the form of the conflicts that may arise between the group members or the team members, and we had a discussion that it can also at the same time challenge the status quo, and it can challenge the existing assumptions of the organization, and it can create more room for flexibility, for innovation, for creativity, which are the landmark of today's organizations. So we also had a discussion on the concept of the affirmative action plan, that how the affirmative action plan is basically a corrective action on the part of the employer to make corrections of the certain mistakes that they have done in the past, and which has disturbed the proportion of the protected versus the non-protected class. We also had a look at the concept of the reverse discrimination, wherein we saw that how the employees who are not belonging to the protected class, they feel that these quota systems, they are by way of these quota systems, they are discriminated against, right? And we had a discussion on the implications for the management of all these different aspects in light of the labor laws in Pakistan, the procedure of grievance handling in the case of sexual harassment cases in Pakistan, and we concluded our lecture 18 with the discussion of all these different topics. So for today's lecture, we'll be discussing the concept of labor relations and collective bargaining. What you can expect from today's lecture is we would start off with why workers they form unions. We'll see that why workers form union. We'll see what is the collective bargaining process. What are the violations of good faith bargaining? We'll illustrate with examples bargaining that is not good faith. We'll see the conditions for good faith bargaining. We'll see the parties that are involved in negotiations or in the good faith bargaining, and we'll see the bargaining items. What are the different mandatory items in good faith bargaining? What are the different voluntary items involved in the good faith bargaining? And what are the different prohibited items that are involved in the bargaining? Then we'll see the bargaining stages and the different processes which are involved in bargaining. We'll see the concept of impasses, why an impasse is created, what are strikes, what are the different types of strike, right? And in relation to this, we'll also discuss the concept of picketing, right? And we'll also see that what procedure and what process should the organization follow if the employees they are on strikes, and if they are picketing, what are the best ways for the organization or for the employer to handle those strikes and the picketing. We'll see the concept of the mediation, the third-party mediation, the third-party involvement, and the arbitration. What is the difference between this mediation and the arbitration? What are their advantages and disadvantages, etc. Then we'll see the different grievances that can arise in the workplace when the employees they are not satisfied with the policy or with the actions or with the happenings in the workplace. And we'll see that how the organization can develop a grievance procedure. And then we'll have a look at the labor laws in Pakistan, right? And with this, we'll conclude our lecture. So starting off with why workers organize, why workers form unions. So that is the first question, that why to unite, why to form union, why to organize. Of course, the first thing that is most logical and that comes to our mind when we say that why we tend to organize, right? That is the solidarity, because we want to gain solidarity. We want to get their fair share of the pie, right? Because they know that when they will unite, when they will be in solidarity, there are more chances that they will get a greater share of the pie in the form of improved wages, in the form of improved working conditions, improved hours, and improved benefits, right? So to protect themselves from the management whims, right? Sometimes they feel that if they don't have unions, because when they have unions they can exert more pressure, that they can say they can have better say to the top management, to the management to the union representatives. They can send their voice to the top management, and they can protect themselves from the different management whims. At least management can get to know what are their concerns and what are their problems through the union representative, right? So conditions favoring employee organization, such as the low morale, fear of job loss, and arbitrary management actions. So the employees, they want to turn them into more favorable when and they want because of the job insecurity, because of their low morale, and because of these arbitrary management actions, the workers, they want to organize themselves and they want to form unions, right? So what is the collective bargaining process? Before we need to know what the process is, we see that what collective bargaining is. So both management and labor, they are required by law to negotiate wages, hours, and terms and conditions of employment in good faith, and that is collective bargaining. So as per the collective bargaining, the employers and the employees, they both need to join together, and they both need to collectively discuss and bargain over a number of issues which are related to the employees' working conditions, which are related to the employees' health, to the employees' wages, their hours, a number of hours working, right, and part-time, full-time, contract, permanent, right, and the terms and conditions of the other terms and conditions of the employment, their holiday plans, right, and so on in good faith, right? And what is good faith bargaining then? Both parties, they communicate and negotiate, right, under good faith bargaining. So they match proposals, both parties, they bring their own proposals, they prepare their own proposals, they bring those proposals, and they negotiate with each other on the basis of those proposals, and then they prepare their counter proposals in a reasonable effort to arrive at an agreement. So they are both willing to make certain negotiations, and they are willing to arrive at a contract or at an agreement. They want to arrive at an agreement or a contract, and for that they make certain negotiations with each other, with the two parties. They prepare their proposals and their counter proposals, and then they arrive at certain contract. So it does not mean that one party compels another to agree to a proposal or to make any specific concessions. Of course, one party, it cannot force the other party, or it cannot compel the other party to enter into certain negotiations, or it cannot force the other party to forcefully sign a contract. right? So both the parties, they need to understand each other, they need to understand each other's demands, and they need to come up with the reasonable concessions for in order to arrive at a negotiation or at a solution for good faith bargaining. It is important that they understand each other's requirements, and then they are ready to compromise, and they are ready to make certain concessions in order to achieve the contract, or in order to reach a solution. So when we say that there are violations of good faith bargaining, the first one is the surface bargaining. When the bargaining is surfaced, right, then we say that good faith, or the conditions of good faith bargaining, they are being violated. So going through motions of bargaining without any real intention of completing a formal agreement. So what is happening here is that the organization is or the employer is going through the agreement in the negotiation process with the union representative. He is just going through the agreement, and he does not have any real intention of completing a formal agreement, right? So that is just surface bargaining. So that is just on surface, but that is not deep down, that is not real, that is not actually intended, right? Then the inadequate concessions. Just as I told you earlier, that when one of the parties, it is not giving the adequate concessions, then that is again a violation of good faith bargaining, because one of the conditions of good faith bargaining that I just explained to you is that both the parties, they have their own proposals, and they after listening to each other's demands, they bring their counter proposals, and they are ready to make concessions to each other in order to make the negotiation successful. But if they are not ready to make any concessions, any adequate concessions, then it means that they are not willing to make good faith bargaining, or that bargaining is not good faith, or they don't have good intentions to enter into the bargaining process. So even when sometimes the concessions are not required, but still they are unwilling to make the concessions, which shows their bad faith. Then the inadequate proposals and demands. When one of the parties is asking for too much, which is not at all acceptable for the other party, that is the inadequate demand or the inadequate proposal, and and this kind of demands and proposals also underlie, or they also depict the bargaining which is not good faith. So here, as an example, if I say that one party is in the labor union representative, if he is, for example, demanding 50% raise in the wages or in the salaries of the employees, then that is a lot, right? So of course that won't be accepted by the employer, right? And that cannot be termed as a bargaining in good faith, because all of a sudden a 50% jump is not possible, right? So your proposals and your demands, they should be adequate, and they should be realistic, and they should be reasonable, and they should be logical. If your demands and your proposals are inadequate, so that the other party cannot accept it, right, and then there is no room for negotiations in this kind of demands, right? And if one party is asking for 50% and other party had made a proposal for 10% or 15%, then there is a gap is just too much, and it may not be possible for the two parties to achieve an agreement or to arrive at a negotiation, right? So in this kind of demands, they should not be made, right? And then the dilatory tactics, they are sometimes used by the employer. The dilatory tactics, that you are just delaying your negotiations, you're making them pending, right? Or you are not meeting at regular intervals, right? All these are the dilatory tactics that are being sometimes used, and these dilatory tactics, they also show that you are not bargaining in good faith, right? Because if you are bargaining in good faith, you would really try to enter a solution and arrive at a settlement and arrive at a negotiation and end up in a smooth contract, right? But when you're using these dilatory tactics, then it means that you don't have a good faith in doing this bargaining. And then sometimes they certain conditions are also imposed by the employer or the employee, and imposing those conditions, that is also unreasonable on the part of both the parties. Then making unilateral changes in the conditions, right? Of course, it is again because negotiation, it is as the name indicates, that it is a mutual process in which the there is labor union representatives who are representing the voice of the employees, who are sitting there on the behalf of the employees, and then we have the managers, who are also the senior people from the management, who are also representing the top management or the higher management, right? So if you will propose the unilateral changes in conditions that may not be acceptable to the other party, if you are trying to impose those conditions, then it means that you are you don't have a good faith in entering into this bargaining process, or you don't want to make this bargaining successful. Then sometimes the employers, what they tend to do is that they tend to bypass the union when they don't recognize the union, or when they don't tend to recognize the union or the union representative. What they do is that they are trying to bypass the representative, right? But he must recognize, the employer must recognize that he must deal with the employer representative, with the employee representative, because it is the collective bargaining process which is between the employee representative and the employer. So the employer, he needs to recognize the employee representative, and he needs to make the negotiations with the employee representative and without bypassing him or her. Then committing unfair labor practices during negotiations, that is also a not good faith bargaining. Such practices may impact poorly upon the employer intentions. Okay, and then the withholding of the information, that is also a violation of the good faith bargaining, where what you're doing is that you must sometimes there is certain information that is available with the managers which is related to these bargaining items or the process of this bargaining item, and it is required by the union representative to further see their case, or further see their point, or to further enter into the negotiations. That is required by the union representative, but the managers or the management, it is not ready to give that information to the union representative. It means that they don't want good faith bargaining to occur or to happen, right? They are not serious in the good faith. They don't have good faith in doing this bargaining. By withholding the information, it is the right of the union representative to get the relevant information if the union representative requires that information, or if he asks that information, then it is his right to get that information, and it is the duty of the managers or the management representatives to give that information. Then sometimes if you ignore the bargaining items, then again you are or you ignore the mandatory bargaining items. So mandatory items, they are the items that must be negotiated upon. In our future slide, we will see what are the different mandatory items, and we see that how important it is for the senior management and also for the union representative to bargain over these mandatory items, because they are mandatory, right? And they are part of your collective agreement, and you must agree and you must enter into a contract on all these mandatory items, right? If you are refusing to bargain on these, it means that you don't have a good faith to enter into negotiations and to enter into a contract. Then what are the different conditions for successful bargaining? A number of conditions are there for the bargaining to be successful. One is the freedom of association, where workers and employers, they are free to form their associations to represent their interests, right? The stability of union, where the unions, they have to be stable for collective bargaining to be effective, right? Union is able to honor the agreement, right? The union stability is important for the successful bargaining, right? And then the recognition of union by the employer is of course very important, because when the employer is bypassing the representative, still it means that he is not recognizing the union, right? So collective bargaining begins after employer recognizes the union that claims to represent the specific group of workers. So if the employer does not recognize the union, then bargaining it cannot be successful. Then again, as I told you earlier, that what is good faith bargaining, and what are the terms and conditions under which we say that the bargaining is not good faith. So for successful bargaining, the bargaining needs to be good faith as well. So both the parties should have good faith to enter into an agreement or enter into a contract. Then the mutual respect, that is the relationship affected and process becomes tense and difficult if any party used unfair practices such as victimization, right? So both the parties, they should be tolerant of each other, they should be humble towards each other, and they should respect each other, they should trust each other, and they should then enter into the agreement. Although all this does not mean that they should not be firm on their point. They should be firm on their point, but they should also at the same time show a little flexibility so that a negotiation can be entered and arrived at. And of course they should show mutual respect towards each other, because otherwise it will really hamper the smooth and harmony in the working environment. Then the supportive legal system is of course very important when it comes to the successful bargaining process. That the employment laws, they should ensure that the process takes place in an orderly manner. How you prepare for the negotiations. First, there are the sources of the negotiating information, and you tap those sources and you get all the information that is necessary for the negotiations. You can different sources that you can have for this negotiating information can be local and industry pay and benefits comparisons, right? And in which what you do is that you make the comparisons between the local and the industry pays, right? So and the pays that are in the local community, right? So for example, as an employee representative, you want to renegotiate the wages of the workers in the organization or the union members in the organization. So what you do is that first you will prepare your case, right? You will collect data. So that data will be from the local community, from the organizations who are operating in your community, or the organizations who are related to your industry, at the local level and sometimes at the national level as well. So that depends upon what kind of workers you are making the negotiations. If you are making the negotiations for the low-skilled workers, or for the administrative workers, or for the sweepers, the moppers, etc., for this kind of class in your workforce, then of course you don't need to enter into national comparisons. The local comparisons will also be sufficient, because your hirings would also be local in all the different organizations. The hirings for these low skilled jobs and the low profile jobs, they are local, right? And for the high skilled jobs or for the technical skilled jobs, often the hirings, they are also they're at the national level. So collecting data from the local level in order to make such comparisons when it comes to the negotiations for the skilled workers, that is not sensible to make the comparisons at the local level. You need to make comparisons at the national level, so that you can have data across the different cities, and by the different multinationals or the national companies who are operating in your country. You can have the data across them, because you made the hirings across the nation. Therefore you also make such comparisons at the same level. And only then they can be the true picture of what you stand, where your company stands, or where your employee stands in terms of these different benefits. And you can make your case that okay, they are getting this much, or they are earning this much, and our organization is giving this much, and this is the discrepancy, and this is our case that we need to plead it, right? Then there can be other sources as well, such as the distribution demographics of the workforce, benefit costs, overall earnings level, and the amount and cost of overtime, right? You need to calculate all those different costs. If the employees, they are entering to work time into the part-time, right? Are they being paid for that overtime work? For the part-time, of course, they would be paid, but are they paid for that overtime work? right, and how much overtime they are entering into, right, what are the different costs of the overtime, what are the benefits that you are giving to the employees, right, and what are the different overall earnings level, what are the overall costs, and if you revise your contract with the employee representative, right, and what are the consequences for that revision. So cost of the current labor contract and the increased cost, that is total per employee and per hour of the union's demands, because of course we know that the cost in the wages, or the wages that is the highest fixed cost that the organization has on account of the salaries, right, and they are the fixed costs, right. So if you need to enhance those fixed costs, then till how much level you can enhance them, how much per employee you will enhance them, and how you would satisfy the union's demands, right. And then the grievances and feedback from supervisors, that can also be helpful for you to make your case, right. And sometimes the employers, when they are preparing their case, they can prepare it with the help of the knowledge of what the employees think about them, what grievances they have about them. They can get this feedback from their supervisors as well, and basing on that, the employers or the employer representative needs to present to or needs to prepare its case. Because the complaints of the employees, they are most expected, or they are more expected to come up on, or to come on surface in this collective bargaining process. And if the employer has prior information of what the employee feedback is on all the different areas in the organization, then the employer can or employer representative can better prepare his or her case. And then there are certain by the counter offers and the arguments as well, you can prepare your negotiations. Attitude surveys to test employee reactions to sections of the contract that management may feel require change, right. So you need to you can get those attitude surveys done to test for the employee reactions over which the management may feel that the change is required, and over those areas you can just get the attitudinal surveys from the employees, and you can get their idea on what they want and how it can be changed, etc., right. So you can get all this information beforehand, and then prepare your case, so that you already know that what are the different demands, what is going on in the organization, what are the different demands of the employees, and how you have to prepare your case, keeping in view all that necessary information. Then there can also be informal conferences with local union leaders to discuss the operational effectiveness of the contract, and to set up trial balloons on management ideas for change, right. You can have those informal meetings with the local union representatives to discuss the case. Okay, so I told you that there are different items, there are different bargaining items, and there are different classes of those bargaining items, and some of them are voluntary, some are illegal, and some are mandatory. Voluntary items, also known as the permissible bargaining items, they are basically those items which are in collective bargaining, over which bargaining is neither illegal nor mandatory. Neither party can be compelled against its wishes to negotiate over those items, right. So voluntary items are the ones which are not mandatory. It's up to you whether you want to discuss them with the other party over the negotiating table or not, right. So they are totally voluntary, they are allowed. So they are legal and allowed as well to be discussed, right. So it is upon the mutual consensus of the two parties. If both the parties agree, one party cannot force the other party to discuss those items, right. And if both parties are willing to discuss those, then they can discuss those, and then they can enter into a contract over those items. But without the willingness of one of the party, they cannot enter into a contract on these items. The illegal bargaining items are those which, unlike the voluntary items which are permissible, these items, they are not permissible, and they are illegal. So there are items in the collective bargaining that are forbidden by law. For example, a clause agreeing to hire union members exclusively would be illegal in a right to work state, right. And then we have the mandatory bargaining items. So mandatory bargaining items are those items which, as their name indicates, they are it is a requirement to enter into bargain over all those items which are mandatory, right? So both the parties, they must enter into the agreement. They should negotiate with each other over all those mandatory bargaining items, and they should come up with an agreement over these mandatory bargaining items. So here is a list of these bargaining items. We have categorized the mandatory items on the left hand side. In the middle we have the permissible, and on the right side we have the illegal bargaining items. So for the mandatory bargaining items, we see that these are the rates of pay, wages, hours of employment, overtime pay, shift differentials, holidays, vacations, severance pay, pensions, insurance benefits, profit sharing plans, Christmas bonuses, company housing, meals and discounts, employee security, job performance, union security, management union relationship, drug testing of employees. So these are all the mandatory bargaining items, and both the parties, they must bargain over these items and try to enter in a contract over these items. So any one of the party is not allowed not to discuss the item, so it is not at their discretion, right? And the permissible items are the ones which are at the discretion of both the parties, and if they want to, they can enter these items and negotiations on these items, such as the indemnity bonds, management rights as to union affairs, pensions, benefits of retired employees, scope of the bargaining unit, use of union labor, prices in cafeteria, continuance of past contract, and employment of the strike breakers. So these are a few examples that I've read for you from the items which are permissible list. Then we have the items that are illegal, such as the closed workshop, separation of employees based on race, right, and other discriminatory treatment, such as any discriminatory treatment that you, for example, you are asking your employer not to hire certain people or not to fire certain people. That is because you want to promote your political activity, your union activity. So all these practices, they are illegal, and other discriminatory practices, they are all illegal. You cannot enter into negotiations, and you cannot enter into a contract over these items. Okay, so what are the different bargaining stages? First step towards this is that presentation of initial demands, right? So both the parties, they are usually far apart on some issues, and they need to they present their initial demands. What do they want? So both the parties, as I told you earlier, they do their homework and they bring their initial proposals, and they discuss with each other their initial proposals. They discuss with each other what they want, and then there is the second stage is the reduction of demands. That is, each side, it tries to trade off some of its demands to gain others, right? You are trying to make a trade-off, you are trying to make a cost-benefit analysis, basically, and you see that, okay, I drop this and I give concessions over here and I get this one instead of this, or if I give this much concession, he gives this much concession, and still it is workable for me, and still it has better benefits, etc. So you reduce your costs by way of concessions, you reduce your demands, and then the third stage is that you form the subcommittees. The union representatives, they have their subcommittee. They discuss those proposals and proposed reductions that they have made in those proposals with their subcommittees, and the management representatives, they discuss with the senior managers, right, and then they discuss the reasonable alternatives. And then finally, when they have made their discussions with the subcommittee, they try to arrive at an informal settlement. They go back to their sponsors. Unions seek to have members vote to ratify the agreement, and then when the both parties, they have discussed their cases with these subcommittees, they form an informal agreement, and then that agreement is finalized and becomes the final agreement. So these are the different stages in the bargaining process. Then we have this bargaining hints, such as be sure to set clear objectives for every bargaining item, and be sure you understand the reason for each, right? So you should be you should have very clear-cut objectives for every bargaining item. Every bargaining item, it should not be without an objective, right? And you should be understand that why you have set those objectives, and you should not hurry. Take easy, and when you are in doubt, don't make decisions, and don't go ahead, don't move forward. So be well prepared with firm data supporting your position, right? Your data should be reliable and valid, and you should have all the data that you require to support your proposal. As I told you earlier, you should be firm in what your demand is or what your proposal is. You should be very clear about it, but being firm does not mean that you should not be flexible. Try to keep a little flexibility in your position, and don't concern yourself just with what the other party says and does. Find out why, right? So if the other party is demanding a 10% increase in wages, then just don't keep yourself to this, that how much percentage increase they're demanding in wages, or the 10% increase, but go beyond that. Try to probe into why they have made this demand, right? Because whatever they were demanding now, it has long-term consequences for you as an employer, and for your organization, and for your employees, right? And maybe you are giving them that concession now, or maybe you are agreeing to that proposal now of 10% increase, but what consequences it has for you in the long term. In the next year, again, maybe they demand 10% raise in wages, or the 15% increase in wages, or what are the motives behind the different proposals that they are initiating. So you need to respect the importance of face saving for the other party. There should be mutual respect, and they should be concerned for that respect for the other party as well, for the face saving purposes, and to remain in harmony with the other party, and to let the whole process in a smooth way. So be alert to the real intentions of the other party, not only their goals but also priorities, right? And you need to be a good listener for good bargaining. Then you need to build a good reputation for being fair but firm. Learn to control your emotions and use them as a tool, right? Don't be over emotional, don't be overreactive, and don't hurry too much in the whole process. So as you make each bargaining move, be sure you know its relationship to all other moves, right? Because there are a number of items that you need to discuss on the bargaining list, which are mandatory for you to discuss. So how those items are interrelated, how one action of yours, or one policy of yours, or one proposal of yours is going to influence the other proposals. What are the different priorities that you have? What are the different priorities that the other party has? How they have set those priorities? What are the effects of those priorities? What are the after effects of those of accepting to those priorities, and so on? You need to make a detailed analysis of all this. Then you need to measure each move against your objectives. You need to pay close attention to the wording of every clause negotiated. They're often a source of grievances. Then remember that collective bargaining is a compromise process. There is no such thing as having all the pie, right? So of course, if one party is not, as I told you earlier, if the concessions are inadequate, or if the compromise is inadequate, or if both the parties, they are rigid and they're not flexible, then they cannot enter into bargaining. So it is both parties, they need to understand each other's position, and both the parties, they need to arrive at a solution wherein they both can get some of the share of the pie, and one party does not have all the share of the pie. So try to understand the people and their personalities. That is really important, that what kind of personalities do the people whom you are dealing with they have, and what do they mean, what is their tone. Consider the impact of present negotiations on those in future years, as I told you earlier, with the help of an example, that how these negotiations, they can affect the future year concessions, right? Then there are a number of labor laws in Pakistan. As I told you earlier, again, This lecture has been prepared from the book written by a US author, and again the laws that were given in that book, they are from US. Therefore I incorporated, replaced them with the labor laws in Pakistan, and again I thought that it's going to be interesting for you, and it is important for you to know that what are the different labor laws in Pakistan when it comes to the collective bargaining process, to the formation of labor unions, and to the rights of the employer and the employees in Pakistan. So we have the National Labour Policy of 2010, and it is basically a comprehensive one, and it includes the preceding 5 policies of 1955, 59, 69, 72 and 2002, and it provides a legal framework to organizations and constitutes a compilation of rules and regulations on various facets of labor relations and laws in Pakistan. The previous policies were mostly complex, irregular and difficult to interpret. However, the NLP 2010 outlines and safeguards 11 key characteristics of labor, which include the workers' right to form unions and provide protection to the union, equitable adjustment of rights between workers and employers, and then it consultations between workers and employers on matters of interest to the establishment and welfare of workers, adequate security of jobs that should be available to the workers and their grievances be addressed. Conditions should be created that workers and employers engage in labor productivity, elimination of forced labor, just and humane conditions of work be guaranteed, and then there are certain provisions which is related to the employment of women and children. Right? As per the Constitution of Pakistan, I think this is the 1973 Constitution, which says that every citizen shall have the right to form associations or unions, subject to any reasonable restrictions imposed by law, in the interest of sovereignty or integrity of Pakistan, public order or morality. Right, so every member has freedom of association as per the Pakistani law. Every member, every individual in an organization, he can be associated with, or he can form a union, he can organize, right? And other clauses or other characteristics of Pakistani law are that no employee can join more than one union at a time. So if the union, if an employee is a member of one union and he wants to join another union, he must give up his the membership, his earlier union membership, to gain a new union membership. Right? He cannot hold 2 at the same time. For the formation of the union, it is important that unions can be formed in the organization only when the organizational size is big enough. That is, if there are at least 50 workers in an organization, only then the organization can form a union, a labor union, right? And for the formation of the labor union, another condition as per the Pakistani law is that at least 80% of the workforce, they should be union members. Only then the union can be formed. Again, no union member can force the non-union member or to join the union. You cannot force anyone else to join the union, right? And similarly, the employer, the duty of the employer, he can also not coerce the employees from not joining the unions. So employer asking the employees or giving the threats to the employees in terms of their promotions or in terms of their salary raises, etc., that if they join unions, they will be to a disadvantage. Employers cannot do that. It is the right of the employee to join the union. I also tell you here that the unions, they have their own policies, independent policies, they have their independent legislation, and they have their independent procedures on how the union activity will be organized, right? And they are independent of the organizational policies and the organizational activities. These unions, they also need to be registered with the registrar of labor unions, right? And this is done at the local or the provincial or the district level, and does not need to be done at the federal level now as per the Pakistani law, right? And other than that, neither the union member nor the employer, both cannot enter into unfair labor practices. And when we talk about unfair labor practices in terms of the union members, they cannot enter into the illegal strikes. And the employer, when it comes to the duty of the employers, it would be unfair labor practice on the part of the employer, one, to coerce the employees not to join union, and also the employer cannot stop the union members to enter into legal strikes. They have the right to enter into the legal strikes, and the employer cannot ask them to stop entering into that right. So these are the different clauses, the important clauses in the Pakistani law that I thought might be important, and you should know them. Then when we do this collective bargaining, if we discuss the collective bargaining process and how it happens, right? And but as a result of the collective bargaining process, if a solution is not reached and a contract is not arrived at, then that is a situation of impasse, right? And it usually occurs because one party is demanding more than the other will offer, and the concessions, adequate concessions, are not given by the other party, or somehow there is no agreement between the two parties, and then that is a situation of impasse. Impasse, when it occurs, it can be resolved through third party mediation, then or through third party. There can be different ways in which the third parties are involved, right? It can be a mediator or an arbitrator, but it is a disinterested person, right? And it is an unbiased person, basically, right? And if the impasse is not resolved in this way, the union may call a work stoppage, a strike, to put pressure on management, right? But when the third party involvement is by way of the mediation is the third party, which is a neutral party, and it tries to assist the principals in reaching agreement by holding meetings with each party to find common grounds for further bargaining, right? So sometimes when you're into directly negotiating with each other, and sometimes the situation is created in such a way that it's difficult for both the parties to enter into or to find the common grounds and to find for more possibilities and more solutions, right? And the mediator can then in such cases do that. He enters into the independent discussion with the two parties and tries to find the common ground for them. But it is important here to know that the mediator is the go-between, and he has no authority to dictate terms or make concessions. He cannot make concessions on behalf of one party or the other party, and he cannot dictate the terms. The mediator communicates assessments of the likelihood of a strike, the possible settlement packages available, and the like. Arbitrator, on the other hand, is a third party involvement wherein he has the power to determine and dictate the settlement terms. So in the case of the mediation, it is not necessary that that dispute will be resolved or the impasse situation will be over and a contract will be arrived at, because the mediator does not have that power. He can only help the two parties find common grounds and arrive at some solution, right? But he cannot, he can only make his recommendations, his suggestions, but he cannot dictate the terms and he cannot make the decisions. But the arbitrator is the person who can dictate the terms or the settlement terms, and he can guarantee a solution to the impasse. Okay, but when no solution is arrived at and when the impasse continues, then sometimes the workers they protest by way of strikes, and the strikes they are of different types, such as the one is the economic strike, which results from the failure to agree on the terms of the contract. So when the terms of the contract are violated, then the union members they enter into this economic strike. So it is the legal strike in which the terms of contract have not been met, right? Then the unfair labor practices, when they are being conducted, and then such as the misconduct by the employer, right? Then against those unfair labor practices, when you're entering into the strike, you can also enter into strike which are the wildcat strikes, where an unauthorized strike occurring during the term of a contract, right? So it is here in the wildcat strike, the conditions of the terms are being met, but still you're entering into the strike. So it is illegal strike or it is unauthorized strike. And the sympathy strike is when one union members or one union it joins the other union to support the other union's cause. Picketing is when employees they carry signs announcing their concerns near the employer's place of business. So employers, they have these posts and they have these signboards, they have these posters which they have prepared, and employees, when they are on strike, they basically want to know the general public that there is something, good relations are not happening between the labor or between the employees and the workers, or between the organization, between the management and the workers. When they want to show it to the general public, to the customers of the employer, or to the suppliers and to the other parties, when the employee wants to give this message to the general public, they do this by way of this picketing, right, in which they make these posters or the signboards, right, near the business place. So employers has a number of options what he can do when the employees enter into the picketing. Employers, they can either shut down the operations till the strike is over. They can contract out work to blunt the effects of strike, right? They just contract out the work to someone else, and they continue operations by using the shift workers, by making the job rotations, and by way of taking extra work from the current non-striking employees, right? Then they can hire the replacements for workers, right? And these are the temporary hirings of the replacements of the strikers, right? And you hire those replacements and you take work from them, and you don't shut down your operations. But the permanent replacement workers, they cannot be hired in case of strikes on account of unfair labor practices, right? Okay, there are different guidelines under strikes for the employer. When the employees are on strike, or when they are picketing, the employer, he should pay the striking employees all their dues on the first day of the strike, and they should ensure that certain security measures have been taken place at the workplace, especially when they have hired the replacement workers. Then their security should be they should be properly secured with the help of the guards or other equipment. Their security should be ensured, right? And the security of the workplace should also be ensured, of the equipment and the machinery, overall building, right? And that should also be ensured. The managers or the organizers or the employers, they should contact their suppliers to see that if the picketing, the way has been the access to the place where the raw material has to be dropped, if it has been blocked by the picketing, then the employer need to see that, contact their suppliers, tell them the situation, and arrange some alternative ways of getting the supplies, so that the work operations are not come to a halt, right? And in case the workers, sometimes in cases of such strikes and the picketing, the employees, the non-striking employees, may have to stay within the premises of the organization or of the business place. So in that case, the employer needs to make adequate arrangements of the overall overnight stay and meals of those non-striking workers. They should also install those cameras and photograph the facilities before and after this picketing is occurring, in order to see that if the picketers or the striking employees, they become violent and they throw material on the building, or they disrupt the operations of the building, and in those violent cases, they can be photographed and they can be recorded in the cameras, right? So the employer thus needs to carefully examine the misconduct on the part of the striking employees. The employer should also note the number of pickets, the time, date, and location of picketing, wording on signs, signboards which are carried by pickets, description of picket cards and numbers. All those things, those records, they should be kept, they should be maintained with them, right? From that time the employees, they go on strike, they start picketing, the employer needs to document everything, to photograph everything, and need to properly secure and guard the workplace and the employees who are being replaced. So what are the different main sections of a contract agreement? We all know that it deals about the grievance procedures, the arbitration of grievances, the management rights, the union security, payroll dues deductions, compensation rates, hours of work and overtime, benefits, vacations, holidays, insurance, pensions, health and safety provisions, employees security, seniority provisions, and contract expiration dates. These are all the different elements of a contract agreement. When there is a grievance, which is any factor involving wages, hours, or conditions of employment that is used as a complaint against the employer, So whenever a grievance occurs, of which there can be different sources, such as the absenteeism, you have been given you have been suspended on account of being absent increasingly, insubordination, where you have been fired on account of insubordination. Overtime, there can be overtime issues, and the grievances can arise, and that on the overplant rules, the different grievances can arise. You are fired on account of misconduct, and there is a grievance, right? And how to handle that grievance. There should be a grievance procedure which should be very much clear and laid down in the organization. Grievant and shop steward, they must meet with the supervisor if not resolved. Employee files formal grievance. Grievant and shop steward meet with supervisor's boss if not resolved, and meeting with higher level managers, and if not resolved, matter goes to arbitration. So what are the different do's and don'ts of handling these grievances? I quickly go through some of these and for your understanding. So when you have to handle these grievances, you first investigate and handle each case as though it may eventually result in arbitration. You talk with the employee about his or her grievance, give the person a full hearing, require the union to identify specific contractual provisions allegedly violated, comply with the contractual time limits for handling the grievance, visit the work area of grievance, determine whether there were any witnesses, examine the grievance personal record, fully examine prior grievance records, treat the union representative as your equal, hold your grievance discussions privately, fully inform your own supervisor of grievance matters. And there are certain don'ts in the grievance handling process. Discuss the case with the union steward alone. The grievant should be there. Make arrangements with individual employees that are inconsistent with the labor agreement. Hold back the remedy if the company is wrong. Admit it to the binding effect of past practice. Relinquish to the union your rights as a manager. Deny grievances because your hands have been tied by management. Avoid to informal amendments to the contract. So they are the different don'ts of the grievance handling procedure. So I just jotted down all those different actions that are desirable to handle the grievances, and all those actions that are not desirable when it comes to handling these grievances. I just try to put them all up in the shape of a bullet point, so that it is more comprehensible for you, and it is more easier for you to understand, and all the things come up to you in the form of a consolidated document, right? And no point is missing. Carefully go through all these points and try to understand the meaning behind these points, right? And I hope today's lecture was really interesting for you. We had our discussion on the different why the labor unions are formed, what is the importance behind formation of these unions, and how the negotiation process begins, what is collective bargaining, what is good faith bargaining, what are the different violations to good faith bargaining, and what are the different stages in the negotiation process, and how a negotiation process can become successful. And we also had a discussion on how the situation enters into an impasse if there is no negotiation, a negotiation is not successful between the employer and the union steward or the union representative. And we also had a discussion on how, as a result to this impasse, it can be resolved through the third-party involvement, and they discussed two types of third-party involvement. One was the mediation and the arbitration. We discussed their differences between these two forms, their advantages and disadvantages, and then we had a discussion on how the employees, they can enter into the strikes if the condition is still of impasse, right? Then they can enter into the strikes. Then there are different forms of strikes we discussed. We also discussed that how they can enter into the picketing as well, when they want the general public to know that they are into the strikes, and what are the different implications of the this picketing for the employer, and how the employer can deal with these strikes, then how the grievances can arise in the workplace, how there needs to be a proper grievance handling procedure in the workplace, and what are the different do's and the different don'ts when it comes to handling of those grievances, right? So with this we come to an end of today's lecture. Have a good time. Thank you. Allah Hafiz.